Yeah, I thought it was pretty good. You apparently have to speak right into the mic. They were yeah, up and down.
Is that true? Then you're right at it. I think we're pretty close to the same.
Yep. Yep.
All right. Well,
We're decision to make. Although he liked many of the things in the 2011, at that time 19,000 employees were laid off. He could have vetoed the tax.
Veto the legislature's appropriation.
This is a political case. It comes up in a political environment. The Constitution, which says you cannot spend money without an appropriate function, that the citizens of Minnesota, the court has to stand.
Exactly what is and is not before us.
A Lyon County case from the
Said in Lyon County that inherent authority, quote, cannot be
but in a circumstance where the legislature, who does have that,
and perhaps a little more simple,
frames this issue before the court now, if the legislature's adjournment could control the governor, all of those things are possibilities, but I don't think they continue the legislative session controls the outcome here.
And wouldn't we be in some way, shape, or form almost by we have put a mechanism that allows on as articulated. And I'm
very light. In the history of the state of Minnesota, is higher. The court parties are unable to listen. Citizens have a right to it.
Contrary to the least dangerous branch.
United States Supreme Court constitutional obligation to fund. Branches of government do not fund let that function disappear. Made by the legislature to elect going into the Ramsey County District Court.
Any settlement discussions either.
I think I'm only thinking what's in the record.
Well, in fact, that shared until after the legislature had adjourned sine die, or that some future legislature could defund the judiciary. Again,
Provide proper word that has been used in this case, and there is no defunding. Who had 2 terms in office have used it over 200 times.
has any governor in the history of the state of Minnesota
Parts of the legislature's budget because it only shows as one line, as opposed to the executive line.
Mr. Hanson, just don't leave for a minute.
is there a sense possibly in which it was nevertheless a constitutional, one of the May 30th letters,
On that million, thousands of negotiations. The party
negotiations when he says, now the May, and I will call a special session, but only if you will change, or words to that.
things were put in
To be here today.
That exception clause is without an exception to the distributed clause.
and this court has already
May not violate the distributive clause.
2 affidavits.
Legislature.
I'm not.
Court, we need this court to break the impasse for us, and I think
Do you agree?
To be adjournment.
well that part is true, and
Fall. Where does that, if I have that scenario correct, should we just leave?
In session and waiting until the governor had made a decision on those bills.
other than their agreement. They screamed bloody murder if they had stayed in session. taken up other matters.
It's constitutional right. They assume they upheld the agreement. They did exactly as they negotiated.
And so therefore, we are...
There's plenty of motive discussion that can be had here, either branch of
Petition for review that the governor has acted.
that if the
That is this. There are lots of concerns about what the implication. There is also the matter of the plain language of the Constitution. I think the subtext of the question that Justice Littlehog asked you is, if you look to the subtext of the Constitution in terms of when the governor can exercise his line item veto, has to be for an appropriation item. He did that here. Even if the implications of this decision are ruinous or disastrous or whatever you may want to suggest, what do we do about that plain language argument?
You're talking about the object to language in the 1876 amendment.
Right. Well, that's a piece of this, but you know, we've got this decision. I mean, we've got the action of the governor. He line itemed an appropriation. The Constitution seems to permit that by its plain language. What do we do about that?
Well, couple of things here. That allowed the line item veto says you have to object to the specific item of appropriation. And that other courts have been those things. You interpret it, then you've got to object to the
Is that part of the argument? Then what? Then how do you by Justice Anderson? Meaning that object is different. Let's assume his question that they are one and the same.
Well, listen, number one, I think that our case is very part, which goes to Justice Littlehog's question as well. If you use permissible tools, but you use them to get an impermissible result or constitutional result, then it can also be by.
Let me comment, and this is as well, my elaboration, but for section 2 limitation to the governor's line item veto, is there in the plain language of Article 4, Section 20 over any for the legislature. That language.
It doesn't occur which we
At the end, they're there.
no, it isn't. You're right.
I know.
You have to go that we have cited in our brief that talks about the, and by the way, the line item veto and the general different power is a construed word in legislature responsibility priorities as a role. Case comes out from the legislature. It's a negative authority. It's not a creative one, and it can't be used to do policy.
And I
So
grant
what
you all
we-
of that,
what-
Mr. Kelly. I agree with your statement. But I still see Article 4, Section 3 call up an item. Governor did creation.
First of
But
all,
Johnson versus Carlson says we don't look behind we don't look at the motive, we don't look at the purpose, just like it would be inappropriate for this court to look at the purposes behind what the legislative case law is legion. And John is very clear that we don't go that next step, that it's the body to do that.
And he found that the clause applies under case that we cited in our brief. Once that there is and the things here, he said use of the law, said it was trying to make back door policy, that he's done here. In other words, you can't use the line item veto to veto item of policy, and my counsel has agreed with that proposition. What the governor has done here is to say, Governor twice budget exactly the same that, and what he want you to come back, and so it's 5. Judge got wrong. You yourself, that's
Counsel, I'm distinction that you're veto and a line item veto, and in that regard, let me ask you this. I watched your argument in the district court, and in that argument, I think you can say the governor could have vetoed the entirety of SF1, the state government appropriations bill. Now, that also would have zeroed out the legislature, because the legislature was in that.
correct.
So, what's your rule of law that you're proposing that it would be constitutional whole thing, including zero legislature? The line effect is the same, isn't it? And it could have added the special session.
It's very different, and let me explain why. When you veto the bill, you veto the whole bill. Both sides lose what they had in the bill. Their things is one. You're back. Okay, what do we negotiate in the political process to get it? A line item veto. The line item veto takes one item out, becomes law, and so you are really just in that way.
It's
That
just
way.
not fair.
What I'm saying is it's different than this because you
Legally, is it in the general line item?
This is all.
yes and do
Same result, because you've been articulating using the district court's language that the line item veto abolished the legislature. Given the question by Justice, the same result. So
Your Honor, because it's involved. If you we would believe they have some kind they would have way that this
asked you that I don't think you answered, largely because everybody else jumped on you. So legislature's in session. Every year, it never happens, but there's talk every year. We're going to get the appropriations done early, and then it never happens. But let's say magic occurs and it happens early, and the governor then line items the legislature. That because they the like opportunity bill be in the political. So this thing about the city.
Now we're down to the nub of it. It seems to me that your client's validity of the veto itself,
No.
but right, all the legislation or not. I don't see any. We certainly didn't have a review on this, where you're claiming that the governor's discretion to call or not call a special session is being abused here. So aren't you essentially valid? Your client doesn't.
This situation where we can't do anything to defend ourselves, and I think it's.
Does your client want out of the agreement? that it
No,
entered
my
into?
client lived up to its agreement with the governor.
Was there anything in the agreement where the governor committed not to veto anything?
Well, listen, I here, but the idea is bills that we agree. And we've all looked at them. Some of the things the governor wants in are not there. Some of the things my clients want are not there, but there's this compromise. And they cut the deal, and then the agreement, the special session, you can't do anything else. You're going to pass these bills, and the assumption is the governor sign them, and he will not veto them.
He said that he was going to sign them. Is there anything in the agreement, or is there any every one of those line item veto? He vetoed this bill.
Yep.
Was there anything in the agreement that he was going to sign the labor standards bill?
Nothing in this.
Anything in the
wording of
agreement that he was not
agreement.
going to line item anything?
Nothing in the word, other than I believe the understanding that the bill will be held.
Did not see the general appropriation bill as with the bills until May 20.
I don't think that's correct. I believe that that provision was in several parts of the bill. I am
That actually saw the bill, that bill, that the poison 25th.
I agree with that.
In a way, and it goes to Justice Lowell's poison, and then hope and pray that the governor will be consigned and resign to sign it.
I'm presuming that the extent of everybody else that they clearly saw there. And veto that process, and everybody has the opportunity
But had he
to
done
come
that,
at
the
it and
Department of
fight.
Revenue would have been defunded.
Me?
Had he done that,
Listen, he could have done that, or he could have signed the bill. He and for functions, and the governor in his letter, the members
little bit is one that declared part of the complaint. There's language about the governor, the legislature, and abolishing into repealing policy legislation, line item veto to control, coerce, restrain the actions of the legislature in the exercise of its constitutional powers and duties. And what just strikes me as odd here is that isn't that exactly what the legislature did by including the poison pill? It was an attempt to control, coerce, restrain the action of the executive branch of its
but it's the government. I don't want to sound was veto at political process.
veto.
Or sign it and come and say
Veto
poison
the
pill was
appropriations
wrong.
bill is what you're saying.
And I said in the used to some sharp elbows in the political process. That's been part here in term. And there are certain tools that you use that rule the power of the veto. If that had happened, we would have been back in session. And
But
I
isn't one of
think
his
things
other
would have.
tools in the toolbox is the line item veto? That is the governor's toolbox. I get to control.
His item veto in our brief back to the main things you're on. The line every different general, and it can raise and certain on
And I
that
guess,
line.
Mr. Kelly, that asked you what matter that puts limits on, other than the constitutional test, so-called, which is that it be an item of appropriation. Other than that, that puts any limits on that line item veto.
Redirect the which says there are line those law here is to be used for
That the guideline item visions of the rationally balanced principle of proponent, because it would be absolute as budget.
Listen, I think government veto, let's say legislature gave themselves an increase veto, talked about it, but it went back into the political process, and that's true. What you can't do is abolish another branch of government, which is what Judge Guthman found occurred here. So,
Everybody's got, all right, thank you. Mr. Hanson, making your way up this question. The judiciary has the constitutional authority to appropriate money. Do we also have the constitutional authority what I'm really trying to get at is, do you think the judiciary has the authority to order the governor to call unconditioned special session?
I do not. I think that would be an invasion of the executive power.
But let me ask you about some future governor who, during the legislature, he or she is not interested in further negotiations. In other words, you can argue about whether or not this is hyperbole here, but that's not hyperbole. That is about line item veto appropriate.
The power might be some this Board of Education. Step in a situation line item with the permanent the crisis. Perhaps the court could step in.
The legislature of either party or of no party would say legislature. Then you have
The case is I'm thinking about all of the possibilities, but I don't know. This is it worked in Minnesota years, even though there are by the Constitution, there was about the protection of 4 Section 23 limits the right of a line item except that it must be an item of appropriation. This court isn't at liberty to imply other lack of history. As you construe the words in the words to it, there's no ambiguity in that clause. It's very clear there's only one limit said, even the is over. The judicial inquiry is over.
But certainly, there's still the Constitution. I mean, the Constitution still sets the bookends, even if there's a specific provision. I mean, you could spin out a hypothetical, the absolutely another provision protection would assert that
such as here.
You have an obligation to figure out how or abused in the future.
But I think the political question doctrine limits your jurisdiction somewhat, that if you can't articulate a judicially that then you're wandering executive how to articulate a standard.
Well, they would say the standard they've articulated is you can't use a line item veto to effectively.
It is not. Now, counsel was asked about was there an assumption that the governor, in the agreement, the governor would not veto the bills. The poison of the appropriate.
He and I were discussing that response to that?
He could have vetoed the appropriation. Where he had 3 appropriation bill, or he could do the more precise, surgical, non-item vetoing the legislature. Had he vetoed the entire appropriations bill, he would have potentially put out of work 19,000 state employees. He had gone through that process in 2011, had no appetite to do it. He was looking for what is the least disruptive measure I can use among the toolkit I have from the Constitution to bring the legislature to discuss the hundreds of items that were in those 10 omnibus bills, but to adversely affect the citizens of Michigan and to the fiscal situation we were in before. Why? I believe he did.
Counsel, could the governor of line item veto?
Encroached upon his veto power, but it provided that if he did exercise
Collect.
Counsel, there's at least a concern that I have, and I think that 11, and which we don't have the authority to do, and like in your view.
it would be hard necessary to perform your function.
Supreme Court, I hope will answer is my veto constitutional? And I believe it clearly is. Thank you.
Governor, does the timing of your veto matter?
Well, good morning. I think it's still morning. I didn't check my clock, but a couple things I wanted to say that we heard in the court case that I just wanted to remind people of. The 5 issues that the governor brought up that he wanted to renegotiate. I want to say that we all agreed upon those issues when we were negotiating. Myself, the speaker, and the governor. That doesn't mean we all thought that they were the things that we should do, but in the end, when we compromised, those were the things that we all accepted. I will tell you that on the Republican side, that we spent more money than we wanted to spend. That was part of our agreement. We didn't spend the money that we wanted on pre-K. We wanted that to go on the formula, but we accepted what the governor wanted there as well. We modified the buffer language. We wanted that more modified, but in the end, we delayed the enforcement. Those are things that the governor wanted that we didn't want. And so I just wanted to remind people that was part of what we did. But today in the hearing status quo, the governor still has all the power that he had. If we rule in the governor's favor, he suddenly has more power than he's ever had before. And so it was listening to them, and I don't know how they're going to rule, but obviously I hope that they rule in our favor.
I would just say that I'm disappointed that the governor continues to fight this. This is a clear violation of the separation of powers. I thought just like the outcome in the district court. We had negotiated these bills in good faith. Our attorney laid out our case very well, and I'm hopeful of a very positive outcome.
Now, Leader, how can you be negotiating good faith if you put a poison pill in the bills to force the governor to sign it, coerce, control, and constrain that?
Well, I disagree that there was a poison pill. The governor saw that bill, his staff. He has many, hundreds of people on staff that saw that bill. It was posted about 39 hours before. Point out that if the governor was planning on signing the tax bill, as he had indicated that he was planning on doing, that wouldn't have been an issue anyway. So I think that well, it was in the bill for at least 39 hours. So for him to say that it wasn't, well, I mean, I think you can look at it of vetoing it. We again on signing the tax bill, despite the fact that that was the information that he had given us.
Several of them as some pretty skeptical.
Right decision.
Yeah, the questions I thought were probing on both sides of the issue. I hope in the end that they do the job that they're supposed to be and rule fairly. And so I'm not worried about it.
Have you been in touch with Speaker Dodd? He's not here, but you know why.
He just has a personal commitment that he's. Why was it important for you to be here in person today? Well, I could have live streamed it, but I had an opportunity to come and see.
Were you just personally curious because you've gone to law school?
Well, I mean, I think this is very important on behalf of obviously the House and the Senate, and this is a huge potential for precedent. So if the court were to agree with the governor, that would be a huge precedent.
Are you pleased to see this development?
I mean that I should pay attention. So. That could potentially ripple across the whole country, moving more power to the governor's branch and the executive branch. And so I wanted to witness this. And I thought the testimony was good on both sides, but I think the common sense, I hope, will lead.
I'm sure curious. Have a right to.
The other side argued today if they were to lose and you were to win, this would tip the balance of power in favor of the legislature permanently. What do you have to say to that?
I disagree completely. If the governor were to win on this, it would, as the Judge Guthman had said, it would literally abolish the legislature. You're taking away a branch of government, and so it would give the governor much more authority than the legislative branch. So I think just the opposite.
But for its own point, do you agree or disagree with that?
No, I think our lawyer made a good point on that in the case in Montana, where the legislature tried to give themselves a big increase, and then that's a whole different discussion. A veto of the whole, the general veto, where the legislature has to come up with the solution. Here it would come back. The governor has to call us back in a special session.
Yeah, and some of the testimony they talked about, the House had about 4 months of resources to continue, but the Senate really only had about a month. And so we would not have been able to function. A number of our chairs have been holding committees on that we're not going to pay. It really would have been effectively would have abolished us.
And I don't think, and I think it's too long. I think it's something more like 2 months. I don't have to get back on that number, but it wasn't 4 months of funding.
One more. Go ahead.
I think it was Hanson suggested that a narrow ruling would be that this would only be like this, it would only rule in favor of the governor if indeed it was narrow and it was a poison pill situation. What do you think of that?
I'm not sure I quite follow your question.
They can only do a line item veto when you put a poison pill in, is what the other side is suggesting. What do you think of that?
Well, for us, it goes back to the separation of powers issue. We just don't think that he can do it. The poison pill, quote, poison pill, it was something he saw about 39 hours ahead of time, or at least his staff did. And in the end, that was the part that the Republicans wanted. We were fighting for it. If he was going to veto that and go...
What's about adjourning sine die rather than letting this play out a little further?
No, in the House and Senate, we usually adjourn sine, say we're done. Sometimes governors don't know what we're going to do after the...
That's just like a professional heads up. I just want
All right. Let's see if we're still live here, folks. Yeah, we are. Hey, folks, it's Mike McEntee with The Uptake. Thanks for watching us today and our news conference, the news conference here that followed. We will have the entire thing up again, so you can if you're watching it over on YouTube, you should be able to rewind and watch it. We had some problems, obviously, with bandwidth. We'll try to put up a better copy if that one's not good enough for everybody to see. And again, if you like this type of thing, support us over at theuptake.org. Your donations make this stuff happen. Thanks again.